Welcome back to another roll call. I'm Joey Sperlazza, an instructor with the J. Harris Academy of Police Training. We had an interesting question posed to us about how U.S. vs. Hunter would apply here in New Jersey by one of our students. He wanted to know, can we here in New Jersey run a criminal history inquiry on a driver during a motor vehicle stop? So let's break down the case. Special thank you to Cindy Glazier. She's a instructor with us here at J. Harris. She's a retired assistant prosecutor from Middlesex County Prosecutor's Office. She oversaw the Narcotics Task Force and is very well versed in arrest, search, and seizure. So let's break down the facts of this case and see what we come up with for New Jersey. U.S. vs. Hunter is a Third Circuit Court of Appeals case. New Jersey falls within the Third Circuit Court of Appeals. However, this particular case came out of Pennsylvania. We have to remember also, when you're looking at a Third Circuit Court of Appeals case, they're looking at it through the lens of federal law, not necessarily state law. This stop lasted for approximately 8 minutes. Running the criminal history took less than 2 minutes of the total of 8 minutes of this stop. The parties agreed that running the CCH was not part of the routine tasks tied to a traffic stop. The court ruled that in this situation, with 2 defendants, 1 officer, the check was objectively reasonable under Rodriguez v. U.S. because it was part of the stop's mission due to officer safety. In Hunter, Trooper Clemens, the arresting officer, testified he runs a CCH only if he has reasonable suspicion that there is criminal activity afoot. That's when I run the criminal history. His primary reason for searching the driver's criminal histories was to bolster reasonable suspicion for purposes of continuing narcotics investigations. It's not regular practice to use it. It depends on the circumstances, and you use it to bolster your belief that there may be criminal activity afoot. We also need to look at U.S. versus Clark, which talks about questioning a driver or passenger about their criminal history while conducting a traffic stop. You cannot ask a criminal history question on a motor vehicle stop that is unrelated to the stop. The officer's inquiry to the criminal history was thus not tied to the traffic stop mission, and at that point, tasks tied to the traffic infraction reasonably should have been completed. The questions therefore impermissibly extended the stop. You may extend the stop when reasonable articulable suspicion is developed. During the course of a traffic stop, an officer must limit the questioning to the basis of the stop and address the traffic violation. However, if during the course of the permissible questioning and detention, the officer develops reasonable suspicion of criminal activity, they may then extend the scope of questioning and extend the traffic stop. In short, you cannot use a traffic stop as a basis to explore the possibility of criminal activity without reasonable suspicion of criminal activity. So unfortunately, we cannot give you a black and white answer as to whether this would be permitted in New Jersey because it has not been addressed by the courts here yet. However, during a routine stop, it would not be permitted. It would be extending your scope of the motor vehicle stop. So I would recommend against that. And by routine stop, we're talking about an uneventful stop, one that ends in a summons or a warning. Most of our interactions with the public are uneventful, routine upon the end. However, we're not discrediting the fact that no stop is ever routine because you don't know who the person is that you're interacting with and what they're capable of until the stop itself is over. I'll say also in my department, I do not have the ability to run a criminal history from my vehicle. I would have to go through my dispatcher. So because of that, I would say that that would be an extension of the stop. So for us, reasonable articulable suspicion and the length of detention would have had been done prior to that running of a criminal history. I would also look at, with us, we use Spillman and Flex. With other services such as InfoCop, we have the ability to see what interactions that citizen has had with law enforcement prior to our interaction today. I would put that under the same umbrella of criminal history checks. So use caution, especially understanding that if you are extending the duration of the stop or the scope of the stop, you need to have reasonable articulable suspicion that a crime or criminal activity is afoot, as well stated here in Hunter. I hope that helps. I apologize that we can't give you a black and white answer, but stay safe and subscribe to our channel for more of these types of roll call videos where we'll keep you informed. If we do get a ruling here in New Jersey that's of a similar fact pattern, we'll be sure to put that out as quickly as possible. Stay safe.